Hello. This is going to be part two of the lecture for this week, where we're looking at freedom of expression. So the first video looked at the Freedom of Information Act and considered what an important tool it is for you as a journalist to be able to get information, access information from public authorities, and demand that they give you the information that you want. And I talked about how you structure that request in order to for it to be effective and you to get that information. But it is a great way of getting stories. The next part of this week, we're going to be looking at accessing courts and challenging the courts. So we spoke a number of times over the last couple of months, but in particular in week one, where we looked at just the basic structure of courts. And also when we're talking about contempt of court, we talked about your right to actually go in and report what's going on in the courts. But it's absolutely essential that you are confident in your knowledge of, firstly, the fact that you do have a right to go in and report what's happening in the courts. But you do need to be aware of the exceptions to that and of how you assert that right. So, accessing the court. So let's go back to that very beginning. Remember when you were mere children, and we looked at this basic principles of law, these basic principles which underline everything we know about the law, really. There's that presumption of innocence and a right to a fair trial, and that's what contempt of court is all about, protecting. But this bit, open justice, and at the time I stressed to you that that's really the principle which underpins our rights and our interests as journalists. Open justice, our right to be able to access and to report on what's happening in the justice system. So it's really important you understand that open justice means open court. So we have a right to go in and report what's going on, but within certain limits. So here's an example. So this was a criminal case. So it's R.V. Errol Incident in 2014. So remember, this is a criminal case. So that's how we state the title to a criminal case. R, meaning Regina or Queen, versus Errol Incident, who was the defendant. Now, Errol Incident was stopped by the police as part of an intelligence-led operation, and they searched his car and found that he had certain things on him, including a data card containing what looked like bomb-making instructions, etc. And he was charged with terrorism offences. And but when it got to court, the judge agreed for Errol Incident, the defendant, and a number of other people with whom he was charged, that they could remain anonymous. And this caused a huge stir amongst the media, because it ran completely contrary to the basic principle that I've been talking about of everything that happens in court should happen openly, and so that there can be public scrutiny of what's happening. Now, this was done because of concerns by the security forces about Incident and about the way that the evidence would be reported, and it might reveal things about the way that he was caught, and all of these sorts of things. So there was a big debate about whether it was right or wrong for this trial to basically remain secret. And initially, it was held to be basically a secret trial, but the appeal court was called in to look at it, and what they said is that even though there were reasons why certain aspects of this trial should remain secret, that they couldn't tolerate having a completely secret trial. So they said that a group of accredited reporters, so members of the press, should be allowed to witness some of the secret hearings that were going on. And that was because the courts recognised that there was a real problem by having secret trials. In the end, Incident was found guilty of some of the charges. So he was found guilty of possessing a bomb-making manual, but he was cleared of plotting an attack in that trial. those accredited reporters, it was very restrictive, so they were allowed to go in, but they had to leave their notebooks in the court overnight. They couldn't take any of their notes out. They were told they couldn't report on it until the end of the trial, and they were very constrained about what they could and couldn't report in terms of how Incidel was caught. So that led to a lot of debate over the rise of sort of secret trials. And the Lord Chief Justice, who was called Lord Thomas then, he made comments on this. So he said, the prospect of an anonymous defendant is one that I hope we would never ever see again in our courts. You can see how uncomfortable this is. One of the most senior judge in the land. He also said, I really passionately believe in open justice. Justice that is not open is not good justice. So this goes to the very heart of the judicial system. That whilst I say that it's that we as journalists, where open justice is the thing that we're particularly interested in because it's it's what we do. We reveal things, we tell people what's going on. But you can see that judges and the judicial system is also very interested in open justice because the fear is that as soon as you start having secret trials, things go on in those trials which may not be just, may not be fair, and even if they are, if people can't see that things are being done fairly, then there's a worry that it would undermine public confidence in the court system and in the judicial system. So, really important trial, and as you can say, it led to a comment from the Lord Chief Justice at the time. Backing that up, a more general principle. So a previous Lord Chief Justice had written this, and this is enshrined in the reporting restrictions in the criminal courts, which is a document which is published to guide the courts in what they should and shouldn't do. So Lord Thomas said, open justice is a hallmark of the rule of law. It is an essential requisite of the criminal justice system that it should be administered in public and subject to public scrutiny. The media play a vital role in representing the public and reflecting the public interest. So you see what I mean? The courts themselves are really, really concerned about the whole issue of open justice and open courts. So they're on our side. We're all pulling in the same direction in that sense. That open justice is a basic principle of the way our courts work. So you need to have the confidence that you have a right to go into court in most situations. Just looking at some of the legal basis for open justice. So the Magistrates Court Act 1980, Section 121, won't necessarily be expected to remember that specific section, but the Magistrates Court Act 1980, it says that magistrates must sit in public when trying someone or considering jailing someone, unless another law permits them to sit in private. But again, to magistrates, they need to sit in public. Also, a situation you may come across, and I've certainly come across it, is where magistrates sometimes refuse to give their names. When you're reporting on a case, you would normally name the magistrates in your report. And just to be clear, that you have a legal right to know a magistrate's name. So there's case law for this, and it's a very famous case of R versus Felixstowe Justices. That case in 1987 was when a magistrate tried to withhold their name. So they just said, you can just call me the magistrate. There's no reason why you should publish my name. Well, there's case law which says that yes, you do have an absolute legal right to report a magistrate's name if they've sat on a case, and they have a legal duty to give that to you. So again, have that confidence that you are allowed to access the courts and you're allowed to report on things like magistrates' names. Here's another example from when I was at the Manchester Evening News. There was a tragic case of a police officer who was stabbed to death during an operation. It wasn't thought to be a particularly controversial operation at the time. It was thought to be an immigration raid up in Crumpsall, North Manchester, and Stephen Oak, who's a detective constable with Special Branch, he was with a number of immigration officers, and they went into a house up in Crumpsall, and they recognised one of the people they found in that house as someone called Kamal Borgas. Now, Kamal Borgas was on an international wanted list as a terror suspect, He was thought to be involved in a plot to poison food in supermarkets with something called ricin, which is a particularly nasty kind of poison. Stephen Oak went to arrest Kamel Bourgass, and Kamel Bourgass grabbed a knife off the kitchen sink and stabbed Stephen Oak. Stephen Oak, a true hero in my mind, kept hold of Kamel Bourgass so that he couldn't go on to stab anyone else, and paid with his life for that decision. So Kamel Bourgass, when he was tried, they split the trial between a murder trial, the murder of Stephen Oak, and a terror trial. And you'll appreciate that if you had those two things going on side by side, one might contaminate the other. That if you're hearing evidence about someone being a potential terrorist, it might prejudice your decisions about whether he's likely to have murdered someone or not. So they split the trials, and there was an order passed on the first trial to prevent the reporting of any of the evidence or anything, even the trial was taking place, until the end of the second trial. So all of this trial was going on in secret, and it went on for months and months until we had a reporter there, but they weren't able to actually write publish any articles about what was going on in court until the very, very end. And again, that was regarded as being a very dubious situation where you had a trial going on which was basically taking place in secret, and we were only able to report on what had happened at the very end of the trial. So these, again, there are concerns that when secret trials happen, you as a journalist should look at these very carefully and ask yourself, is this right, and then potentially seek to challenge what's going on. And we try to challenge that decision. Those of us at Imaginative News were very uncomfortable with the idea of a secret trial, but we were not able to overturn that particular decision. So there are exceptions to open justice. So the default should be that justice takes place in the open, that the courts sit in open session, and that you as a journalist are allowed to go in. So there has to be a good and lawful reason for a court to exclude the press and the public. So that's only when the court can legitimately argue that by doing it in public, by holding that case in public, that it would impede the administration of justice or render it impractical. So if by having the case going on in public it would undermine justice, then that would be one of the few times when a court may not sit in open session. And this happened in Northern Ireland quite a lot. So you'll notice that the judge who's been named there, Lord Diplock, in Northern Ireland during the height of the Troubles, they used to hold what were called Diplock courts, which were basically secret courts because witnesses lived in fear of giving evidence against terror organisations, and they feared that if they were seen in court and seen to be giving evidence, that would stop them giving evidence. So in that situation, there were secret trials taking place in Northern Ireland. There are some other exceptions, similar points really, that if media presence would frustrate the process. So there can be times when if somebody is giving very personal evidence, a judge may feel that that's not something which should be done in public. Trade secrets, so if there's issues of national security or commercial sensitivity involved, then the court may be cleared for those sorts of things. If there are children involved and they're discussing issues of family law, again, journalists may be required to leave. And again, protecting vulnerable people with mental incapacity, then again, a judge may decide that it's not in the interest of justice for the case to be reported. These are very unusual cases though, and again, the important thing is that you maintain a general view that as a journalist you should be permitted access to a court. Just some going through some of the lingo that you use, some of the terminology. So you'll hear people talking about discussions taking place in chambers or proceedings taking place in chambers. So that's proceedings which take place outside of the actual courtroom. They're actually taking place in the judge's office, those discussions. Different to that is when something is held in camera. So in camera means out of sight. That's held in the courtroom, but the press and the public are excluded. So out of sight of the press and public, but in the courtroom. It's important also to know that if you find out about what was said in chambers or what was said in camera, if a lawyer tells you or something, you still can't report that. That ban on reporting it continues after the actual event. So that's accessing courts. Basic principle is you have the right to access the courts. What about challenging? So if you feel that you are being excluded from a court illegitimately, or if you feel there's an order being placed on a case and it's unlawful, it should not have been put on there, what do you do? So if you're in that situation and a judge or a magistrate has placed an order on a case which has restricted what you can report, and you feel that it's inappropriate, you can challenge it. First thing to do though is you need a copy of the order. So if they've made an order, it should be in writing. They can't just make it as some offhand statement. An order has to be a formal written document. So ask for a copy of the order, and the best way to do that is to ask the usher to pass a note to the clerk. So you could just jot down a quick note from a page ripped out of your notebook, give it to the usher and say, could you pass that to the clerk? I would like a copy of the order that's just been discussed. Because only once you've seen the order, then you'll see under what section of what piece of legislation the order has been made, and that way you can look up the details, and that way you can be sure of your grounds, because it might be something you don't know about, and there might be a completely legitimate order. You shouldn't just stand up in court waving your hand and say, hang on, I challenge that. You need to do things in a respectful manner in a courtroom. So the usher, who's basically the person who's making sure people are behaving in the courtroom and seeing people to their seats, pass them a note, ask them respectfully to pass that note to the clerk who sits in front of the judge or the magistrate, and they will then decide what to do next, and they should give you a written order, a written copy of the order. Also, orders, they should also be posted on the door of the court. That's another general tradition within courts. They'll post the order, put a written copy of the order on the door, and when you go into a courtroom, take a look, see if there are any orders on the door, to make sure that you are obeying any orders that have been passed. So if you want to challenge in person, once you've got a copy of that order and you know what it's about and you think it's been inappropriately passed, you need to pass a note to the clerk, or you might wait until there's a recess or a pause in proceedings. You could approach the clerk, not while the judge is in the room, but while the clerk's there, and say you want to challenge the order because you feel it's not an appropriate order, and they may say, okay, well, when the judge comes back in, we'll allow you to make that challenge. Or you can challenge in writing, and that will usually be that you would call your news desk and say, there's been an order put on this which is banning the identity of X, Y or Z, but I don't think it's right. And then either the editor or the news editor may well write a letter which is passed to the judge or to the magistrate, and they will decide what the course to take. And usually if they've had a letter from an editor or a news editor, they may make provision within the case for representation to be made within the next 24 hours or so. So that's the opportunity where you say, no, I think this is wrong because, and you need to have legitimate reasons. It's not just it's making my life difficult. It needs to be, well, an order cannot be passed on. For instance, we looked at the example of a dead child. You can't pass an order banning the identity of a dead child, for instance. So if that happened, you would need to challenge that. You can keep on pursuing it. So if the one court refuses to lift the order and you still think it's inappropriate, you can take it to a higher court. There is a decision to be made there about whether the legal costs mounting up become too high or not. So here are some typical orders you might wish to challenge. So a Section 4.2 order, so you might remember a Section 4.2 order. I'm hoping you're already murmuring, yeah, that's a temporary ban on publication. So if a Section 4.2 order, that's saying you can't publish this information until this point in the future, usually until the end of the trial. That would be the typical time when a Section 4.2 order would then be lifted. A Section 11 order under the Contempt of Court Act, that would be a permanent ban. So typically that might be the identity of a security officer or of an undercover police officer or something like that. The court might say, well, you can never publish this. This is a permanent ban on ever publishing this information. Or, if you remember, we'll look in a moment, hopefully jog your memory, Section 45 of the Youth Justice and Criminal Evidence Act. So that's the piece of legislation which allows an adult court to place a discretionary ban on identifying a juvenile. So if a juvenile, someone under the age of 18, appears at a Crown Court, for instance, charged with a serious offence, and that's why they've gone to Crown Court, there's no automatic ban on identifying them, so the judge would then need to pass a Section 45 order banning the identification of that juvenile in the adult court, in the Crown Court. So it does happen. You can see how lots of occasions, and I'd really recommend you read things like the trade press, things like the Press Gazette, which is the one on the right, or Hold the Front Page, and that's an article taken from Hold the Front Page on the left. The links are in the slides if you want to read these in more detail by looking at the slides on Blackboard. But these are examples of reporters basically challenging orders which they felt were inappropriate. And on the left there was an order applied for by a police constable who was caught for prosecuted for drink driving, and they asked the court to ban details of their address and identity, saying that they were a particularly vulnerable person because they were a police constable, and the reporter said, well, this is not right, and challenged it, passed a note to the clerk, and said that such orders are not there for the comfort or to prevent the embarrassment of officers. They're there for very particular reasons, and the court backed down. The court agreed that that was an inappropriate use of an order. And on the right, in that Press Gazette article, so there was a couple who appeared charged with neglecting 2 young children, and the journalist recognised that was an inappropriate use of an order because the court placed an order on the identity of the children. And what the journalist argued was that if you banned the identification of the children, it effectively banned the identification of the adults. And that's again not the intention, not the purpose of an order, to use an order on the identity of a child, which then effectively bans the identity of an adult. So again, that court backed down and lifted that illegitimate order. So always worth looking at trade press, seeing what reporters are actually doing in practice from a day-to-day basis, that they have got the courage to actually recognise and challenge an inappropriate order. So hopefully you remember this. Remember Section 45. Remember that diagram I came up with talking about when you have automatic bans and discretionary bans for juveniles. Well, Section 45, discretionary ban in an adult court. So adult court like a Crown Court. If this is probably the most common type of order which is passed inappropriately in courts. What that legislation says that it should be banning the identification of a juvenile in an adult court. But if there's no clear reason given for that, other than the age, you should challenge it. If there's a really strong public interest, if there's an overriding sense of public interest which might lead to a deterrent effect, so if it's a very high profile case and a juvenile has been involved in that case, you should make a representation to the court to say that it's important that people know who's involved. If the juvenile involved is very young, if it's a baby is not going to be disturbed by publicity, so you can challenge it if a Section 45 order has been passed on a very young child. If the juvenile's identity is already in the public domain, so if it's already been passed around widely through social media, etc., you can certainly make an argument to the court to say, well, everybody knows the name already, so placing an order on it is it's basically too late. You need to make that, put that to the court. Don't just take it on yourself to say, oh well, everyone knows it anyway, so I'll just break the order. If it's being used to protect the identity of a dead child, you should definitely challenge it, because that is an inappropriate use of an order. And if it's being used to give anonymity to an adult, as we saw in that previous article, so if a Section 45 order is placed on a child in a case banning the identity of that child, but that the effect is that it gives anonymity to an adult, then that's incorrect, and you should challenge it. But it's really important, because remember, we respect the courts, even if the courts get it wrong, and they will get it wrong from time to time, but we must respect courts. And so even if the order is clearly invalid, so if you go into a court and you see them putting a Section 45 order on a dead child, and you're sitting there thinking to yourself, well, Ian told me that that's plainly wrong, and that's correct. It is plainly wrong to put a Section 45 order on a dead child. You need to challenge it first, and until the court has lifted it, you must obey it. Even though you know it's incorrect, you must obey it, and that's a sign of respect to the courts. So that's a really important area, that not only are courts open to public scrutiny, and we are the eyes and ears of the public as journalists, but also that you have the courage to challenge things which you think are inappropriate. It's not just things you don't like personally, things that are inconvenient for you, but it's based on your knowledge of the law. So you must have a good working knowledge of the law, so that then you can challenge the courts, and you challenge them respectfully, but you can be robust. You can make your case, and if you've got a good working knowledge of the law, you will spot plenty of occasions where orders are placed inappropriately. And also you'll have plenty of occasions where people try to stop you going into courtrooms where you've got a perfect right to be. There are very few times when you can't actually go into a courtroom because of this open justice principle. So be confident in your knowledge of the law and your rights of access. So I'm going to end this bit of the video now, and then I'm going to move on to another section looking at your right to take pictures and video in a public place. I'll see you for that video shortly.